Good morning. This is Judge Alyssa Perez resuming the civil docket for the 210 District Court for October 19th, 2022. Again, all matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
In cause number 2022, DCB 0577, Katie Jo Munoz versus Timothy Eugene Myers. Announcement of council, please.
Good morning, Judge Ruben Ortiz, standing in for Mr. Riojas on behalf of Katie Jo Munoz.
Good morning, Judge. Peyton De La Garza on behalf of the defendant, Timothy Myers.
Good morning, council. Okay, status conference today. This is another one. I think we had an answer back in April, but for some reason, we have not had a scheduling order entered. Was there some agreement as to why we were not going to do this? Is this settling, on the verge of settling, or if not, we need to get a trial setting?
I don't believe in any kind of agreement. I think we do need a trial date.
So yes, Judge, so I talked to Mr. Riojas, he's out of town right now, but he said we'd be ready for this trial at any time after spring, Your Honor.
Beautiful. Okay, so then we'll do the same July. Did we do a July setting already, Myrna?
It was July 21st, Judge.
Okay, so let's do that. July 21st. It will have a July 19th docket call, 30 days before the docket calls the final civil pretrial. So your mediation deadline will be the day before that final civil pretrial. Again, please agree to a mediator and include it on your scheduling order. So I don't have to pick one if you all can do that. And we'll go ahead and get you all your settings, but you'll have the 2-week setting by which to turn in the scheduling order. Okay.
And just real quick before the court, Your Honor, we did file a motion to compel discovery responses because we had plaintiff's discovery responses were due back in June, and we have not gotten them yet. So do we need to hear that at a separate time?
I can respond to that real quick, Judge, with regards to the discovery, Judge, and I don't mean to cut in.
Well, no, let me stop you right there. Why don't you all discuss that? Ms. De La Garza, okay. If you need a hearing on your motion to compel, email it to Ms. Hernandez with your request for a hearing. So if I don't get one, I'm going to assume that you don't need a hearing on it and you all are working on it. Okay?
Sounds good, Judge.
Thank you.
Thank you very much.
Thank you, Judge. May we be excused.
Thank you for your time.
Thank you, Judge.
Who's next?
Staying on page 3, Judge. In cause number 2021, DCB 3692, the state of Texas, El Paso County Attorney Joanne Bernal versus Min Juan Zhang et al. Announcement of council, please.
Amy Monsiváis on behalf of the state of Texas. Good morning.
Good morning.
Good morning, Your Honor. Omar Carmona on behalf of the party. I'm never going to pronounce your name right, but on behalf of the party, Your Honor, I don't know what's appropriate to announce on this type of hearing. If I'm clearly not ready, as I've not had any contact with my client, but ready to proceed as the court deems necessary.
You're present, Mr. Carmona. Thank you very much for being here. I think when we left last time, there was some concern, I think legitimate concern, because of the nature in which your client, I'm going to say it like this, although I know it's not going to actually be accurate, had notice of what the parameters were in terms of the protective order. Ms. Monsiváis had raised the concern at proceeding forward with any type of contempt with that type of, I'll say, notice in quotes. So does anybody have any input on that?
Judge, I didn't find anything saying that the motion for contempt could not go forward. I didn't see anything requiring any sort of publication or notice by publication, so I think we can proceed. My intent for a finding of contempt is not to ask for any jail time or even any significant monetary. I just want a judgment showing that she had violated the order.
Mr. Carmona, did you have an opportunity to look at that issue? Or do you have a response?
I don't have a response, Judge. I mean, I did look at it, Judge, but I don't have a, I mean, it's so hard to make any representations when I haven't spoken to her.
Understood, but do you have any position in terms of proceeding on the motion for contempt?
No, Judge.
Okay, then Ms. Monsiváis, you may proceed. And I'll just tell you right now, if there was any proposed order, I'm fairly certain that it's well buried in all my emails. So if you have that, if you'll forward it over as well. Go ahead, Ms. Monsiváis.
And I don't have it right this minute, but I'll have one for you at the end of the day.
Thank you.
Your Honor, under this cause number, the defendant was served with citation on October 21st, 2021, for a temporary injunction hearing set on November 1st, 2021. An answer was filed by the defendant through Mr. Carmona on October 27th. And soon after, all the parties agreed to a Rule 11 to postpone the temporary injunction hearing on November 1st. After that, Mr. Carmona didn't have any contact with the defendant, is my understanding, and a post-answer default was filed against defendant's son on April 12th, 2022. And among those conditions were that a fine should be paid, but more significantly is that she should not operate in a massage establishment and she shouldn't violate conditions of the Civil Practice and Remedies Code under Chapter 455. After that, and the court can see in Exhibit 1, the state filed a temporary restraining order against a different massage parlor called New Life on 1188 North Yarborough Drive, where the defendant's son is named again as a party, as a defendant, for offering massage services. Exhibit 2 is a sworn affidavit from Detective Guevara from April 19th, 2022, where he was working in an undercover capacity. He was offered massage services and also for $40, and also was offered more, the way he describes it, where she is trying to touch his crotch area and motioned in her hand gesture to what he describes as a hand job, so manual manipulation of the penis. And she asked him more than once if she could perform that service on him, which is a violation of the Occupations Code. And then Exhibit 3 is similar, another affidavit from Detective Guevara from an incident on June 16th, 2022, where defendant's son was working again. She again not only offered massage services while she's still in license, but she also asked if he wanted more in motion to his waist. So I think that those are violations of the original post-answer default judgment. And so the state is asking for a contempt where we're going to ask that the judge finds that she violated the default judgment by violating Civil Practice and Remedies Code, Chapter 455.
Okay, so Mr. Carmona, you're telling me you're not ready to proceed on this?
No, Your Honor.
Yeah, I don't know. I mean, and the sole basis for that is because of the disconnect, I guess, with your client, right?
Yes, Your Honor. I mean, when Ms. Monsiváis told me that, she was initiating these proceedings, I thought I was under the impression that everyone was out of town. Obviously, the state has some different intel, but I have not had any contact with them, Judge.
Have you made any attempts, or do you need assistance in possibly, I mean, based on what the county attorneys are representing, I think as I remember how things have gone on, there was this idea that they may not even be, even in the country. Clearly, with the allegations that are in the motion for contempt, we have some idea that she's potentially around town. And so have you made any efforts to try and locate her and speak with her?
Yes, Judge. So there were two individuals that they were all part of the this case in the very beginning. And Mr. Weiser was representing, I guess, someone who would be considered to be, I guess, a manager or, a person that runs the operation. And I have reached out to Mr. Weiser's clients, and they too have not heard from these individuals.
And And really, just so the court's aware, the state's purpose is not necessarily to punish the defendants even more. It's to keep a record, a track record. So if she shows up again, you know, I've got more to show that she continues to violate these statutes.
Right. Okay. All right. Well, then I'm just not really, I think Mr. Carmona is in a difficult spot here in trying to respond on behalf of his client. But I'm going to go ahead and grant the county's request and find her in contempt based on what has been provided in the motion. And so, Ms. Monsiváis, if you would please provide the proposed order on the contempt so I can review it, and then we'll circulate whatever copy is completed to you as well, Mr. Carmona.
Yes, Your
I'm not going to say I don't imagine we won't come back on something, but I feel like we won't. If we do, well, we'll see where we go from there. All right.
Thank you, Judge.
Anything else?
Not from the state.
Nothing
Thank-
further, Your Honor.
Thank you very much, counsel. Take
Thank
care.
you.
You
Thank
are
you.
excused. Bye-bye.
Have a good day.
Thank you.
All right, who's next?
That's it for now, Judge. Mr. Guardiola was in another court.